We will now read to you the argument section of the answer brief, which is really the most interesting part because you have an excellent appellate attorney breaking down the arguments from the appellant, Mr. Adelson, and demonstrating why the arguments should fail. So let's start with part one. Argument. Part one, a change of venue was unwarranted, and Adelson's argument is procedurally barred. Adelson contends that the trial court should have granted his oral motion to change venue, but Adelson affirmatively accepted his jury, thereby waiving all the objections he made during jury selection. Also, the record shows that Leon County residents were perfectly capable of deciding Adelson's case based on the evidence presented in court. A. Adelson waived his change of venue argument by accepting the jury without objection. At the completion of jury selection, the trial court asked Adelson if he accepted the jury. Adelson replied, "Yes, Your Honor." The trial court then swore in the jury, and Adelson never renewed his motion to change venue. The Supreme Court of Florida said in Armstrong v. State that a motion for change of venue should be renewed at the conclusion of jury selection or be considered waived. Jury selection issues are deemed waived after acceptance of the jury, unless the objection is renewed or the jury is accepted subject to an earlier objection. Because Adelson waived all his objections to the jury, this court should reject Adelson's first argument without even reaching the merits. B. Adelson failed to comply with Florida Rule of Criminal Procedure 3.240. Rule 3.240 says that every motion for change of venue shall be in writing and accompanied by 1. affidavits of the movement, and 2 or more other persons setting forth facts on which the motion is based, and 2, a certificate by the attorney for the moving party that the motion is made in good faith. Adelson made an oral motion to change venue without providing any supporting documents. Adelson's motion, therefore, was legally insufficient. This court should affirm the trial court's ruling because Adelson's motion was legally insufficient, even though the trial court denied Adelson's motion on other grounds. Appellant contends that the trial court erred in failing to grant his request for change of venue. However, this issue has not been preserved for appellate review because the motion to change venue was neither written as required by Florida Rule of Criminal Procedure 3.240 and requested by the judge, nor ruled upon by the trial court. As a threshold matter, we know that appellant's offers no record evidence of compliance with Florida Rule of Criminal Procedure 3.240b1. However, assuming arguendo that appellant's oral motion was procedurally sufficient, we review this claim on its merits. That was a quote from a case. All right, C. If this court reaches the merits of Adelson's motion to change venue, the standard of review is fundamental error. In his initial brief, Adelson argues that the standard of review is abuse of discretion. This is wrong. Adelson failed to preserve his objection to venue because he never filed a legally sufficient motion, and he never renewed his objection before the trial began. If this court considers Adelson's unpreserved argument on the merits, then Adelson has the burden to demonstrate fundamental error. To demonstrate fundamental error, Adelson must show that a verdict of guilty could not have been obtained without the assistance of the alleged error.
D. Leon County residents were capable of trying Adelson's case solely upon the evidence presented in the courtroom. A defendant seeking a change of venue carries a heavy burden. He must demonstrate that the general state of mind of the inhabitants of a community is so infected by knowledge of the incident and accompanying prejudice, bias, and preconceived opinions, the jurors could not possibly put these matters out of their minds and try the case solely upon the evidence presented in the courtroom. Adelson argues that he was entitled to a change of venue under the McCaskill case due to the pretrial publicity surrounding his case. The defendant in the Rolling v. State case made the same argument unsuccessfully. Danny Rolling gained infamy by brutally murdering 5 University of Florida students in 1990. The Associated Press described Rolling as Florida's most notorious serial killer since Ted Bundy. Despite Rolling's portrayal in the media, the Florida Supreme Court held that Rolling was properly brought to trial in Alachua County, where he murdered his 5 victims. The Supreme Court rejected Rolling's change of venue argument, using a 2-prong analysis that considered 1. The extent and nature of any pretrial publicity, and 2. The difficulty encountered in actually selecting a jury. 1. The pretrial publicity surrounding Markel's murder did not prevent Adelson from receiving a fair trial. Adelson cannot meet his burden under the first prong of Rolling. To demonstrate that the extent and nature of the pretrial publicity warranted a change of venue, Rolling gives trial courts 5 factors to determine whether pretrial publicity warrants a change of venue. 1. The length of time that has passed from the crime to the trial, and when within this time the publicity occurred. 2. Whether the publicity consisted of straight, factual news stories or inflammatory stories. 3. Whether the news stories consisted of police or prosecutors' version of the offense to the exclusion of the defendant's version. 4. The size of the community in question. And 5. Whether the defendant exhausted all his peremptory challenges. More than 9 years passed between Dan Markel's murder and Charles Adelson's conviction. In Rolling, the court found that a change of venue was unnecessary when 3 and 1.5 years passed between the murders and Rolling's trial. Adelson failed to make a record as to whether the publicity surrounding Adelson's trial consisted of straight, factual news or inflammatory stories. Most of the prospective jurors learned about Dan Markel's murder through professional news outlets like ABC, CNN, Fox, and the Tallahassee Democrat newspaper, as well as WCTV, a local television station affiliated with CBS. Nothing in the record suggests that these professional news outlets said anything inflammatory about Charles Adelson. The pretrial publicity in Foster v. State was more inflammatory than any of the media coverage surrounding Adelson's case. Still, the Supreme Court of Florida held that Foster was not entitled to a change of venue. Foster was the leader of a group of young men in Fort Myers that called themselves the Lords of Chaos. These young men murdered a high school band teacher who caught the Lords of Chaos vandalizing a school. Foster moved to change venue because of the negative publicity leading up to his trial. As part of his motion, Foster provided newspaper articles and television broadcasts reporting his plan to go to Disney World and kill black tourists. One of these articles referred to Foster as a psychopath, Opie with a gun, and a Jekyll and Hyde character. Another newspaper article, published just 2 days before Foster's trial, read, "Old Sparky's hot jolt may await Foster." The same article called Foster a redneck racist and a gun-crazed punk. Despite such negative publicity, the court held that the media coverage as a whole did not reach such an inflammatory level to have irreversibly infected the community, so as to preclude an attempt to secure an impartial jury. Adelson also failed to demonstrate that the publicity surrounding his trial supported the state's viewpoint. Nothing in the record suggests that the major news outlets served as a mouthpiece for the police or the state attorney's office. One prospective juror did volunteer that former prosecutor and court TV host Vinnie Politan had expressed negative views about Adelson. But this juror could not remember what Politan said. The juror also took Politan's negative view of Adelson with a grain of salt. Politan is from Jersey. He's a prosecutor. He has opinions about a lot of people, and they're normally not positive.
Adelson cannot argue that his trial occurred in a small community. According to the United States Census Bureau, Leon County had 292,198 residents in 2020. By comparison, there were 181,596 residents in Alachua County in 1990, 4 years before Danny Rawlings' trial. If Rawlings could receive a fair trial in 1994 Gainesville, then Charles Adelson could receive a fair trial in 2023 Tallahassee. Adelson's use of peremptory challenges also undermines his argument. Adelson did not use all 9 of his peremptory strikes until the end of jury selection, when he used his leftover peremptory challenges to backstrike 2 prospective jurors. At this point, the state and Adelson had already accepted 12 jurors for the main jury. If the minds of Leon County residents were truly infected, then Adelson would have run out of peremptory challenges long before 12 jurors were seated. 2. Adelson had no difficulty in selecting a jury.
While 22 prospective jurors said they could not be fair, 30 of the prospective jurors had never heard of the Markel murder. Also, whenever a prospective juror expressed an opinion about Adelson's guilt, the trial court erred on the side of caution. Once a prospective juror has provided that opinion, it definitely skews towards their excusal. At the end of the initial screening, Adelson agreed to 58 prospective jurors for the final phase of jury selection. Adelson's case was not like Manning versus State. Adelson relies on Manning, one of the few cases where the Supreme Court of Florida found that a trial court abused its discretion by not granting a change of venue. The defendant in Manning was a black man accused of murdering 2 well-liked Caucasian deputies in Columbia County in 1976. The court described these murders as the main topic of conversation in this small rural community. At the time of the 1980 census, 35,399 people lived in Columbia County. Because of the local animosity towards Manning, the public defender's office recused itself, and Manning had to be moved to a jail in another county for his safety. The court described the news coverage surrounding Manning's case as intense, adding that both the police and the prosecutor made press releases relaying their version of the deputy's murders. The court also noted the extent to which Manning's jury pool was tainted. Every member of this prospective jury had knowledge of ex parte statements of the evidence against the accused. Adelson's case was nothing like Manning. Tallahassee in 2023 was not a small rural community. None of the prospective jurors interviewed mentioned press releases from the police or the state attorney's office. Not every prospective juror had heard of Markel's murder or Adelson's prosecution. Also, Adelson's case did not involve the racial hostility that influenced the Supreme Court's
holding in Manning. 2. Striking the jury panel was unnecessary, and Adelson's argument is procedurally barred. Adelson argues that the trial court should have struck the entire jury pool because a few prospective jurors made comments about Adelson's case in the jury waiting room. But Adelson affirmatively accepted his jury, thereby waiving all the objections he made during jury selection. Also, the comments by prospective jurors did not warrant striking the panel because those jurors did not mention facts that would not otherwise be presented to the jury. A. Adelson waived his argument by accepting the jury without objection. Adelson affirmatively accepted his jury without reserving his objection to the jury pool. Adelson also failed to renew his motion to strike the jury pool after the trial court swore in the jury. This court made clear in Johnson v. State that a defendant must renew any objection to the jury pool before the jury is sworn. Appellant claims the trial court abused its discretion in denying his motion to strike the venire. This claim is not preserved for appeal because appellant's motion was not renewed once jury selection was complete or before the jury was sworn.
Because Adelson waived his objection to the jury pool, this court should affirm Adelson's conviction without considering his argument on the merits. B. Adelson failed to comply with Florida Rule of Criminal Procedure 3.290. Florida Rule of Criminal Procedure 3.290 requires that a challenge to the panel shall be in writing and shall specify the facts constituting the ground of the challenge. Adelson's oral motion was legally insufficient. This court recognized the importance of a written motion in Cargill v. State, holding that defendant's objection to the jury panel was not open for consideration on review, because it was not in writing and untimely. Because Adelson failed to comply with Rule 3.290, his argument is either waived or unpreserved. C. If this court reaches the merits of Adelson's argument, the standard of review is fundamental error. Adelson argues that the standard of review is abuse of discretion. Adelson is mistaken. Because he failed to preserve his motion to strike the jury pool and failed to file a legally sufficient motion, Adelson's argument is unpreserved. Adelson, therefore, has the burden of demonstrating fundamental error. To demonstrate fundamental error, Adelson must show that a verdict of guilty could not have been obtained without the assistance of the alleged error. D. The isolated comments of a few prospective jurors did not warrant striking the entire jury pool. Adelson moved to strike the jury pool after a handful of prospective jurors made comments about Adelson's case. The Supreme Court of Florida said in Johnson v. State that,
in order for the statement of one venire member to taint the panel, the venire member must mention facts that would not otherwise be presented to the jury. Most of the prospective jurors cited in Adelson's brief only spoke about facts that were eventually addressed during Adelson's trial. One of the prospective jurors said Markel's murder happened 9 years prior. Another member of the jury pool incorrectly believed that Adelson's case was a federal case. Other members surmised that they had been called for a case concerning the murder of an FSU professor. One of the prospective jurors mentioned Markel's kids and the divorce. Johnson makes clear that these comments were no reason to strike the entire pool of prospective jurors. No venire member in Johnson's case mentioned a fact that would not otherwise be presented to the jury. Adelson also complained that 2 prospective jurors expressed their opinion that Adelson was guilty. But the Supreme Court said in Johnson that a venire member's expression of opinion before the entire panel is not normally considered sufficient to taint the remainder of the panel. The prospective jurors who expressed opinions about Adelson's guilt could not have poisoned the whole jury pool. One prospective juror merely mentioned to another jury pool member, "I think he did it." The other prospective juror expressed his opinion that Adelson was guilty and that jury selection would last all day. These 2 comments about Adelson's guilt pale in comparison to the statements at issue in Brower v. State, where a group of prospective jurors discussed hanging the defendant instead of sitting through a long trial. While the Brower court found these comments shocking, the court affirmed, holding that the defendant received a fair trial from jurors who had not acted offensively and were not otherwise tainted. Like the defendant in Brewer, Adelson received a fair trial from well-mannered, untainted jurors. 3. Adelson's text messages reflecting normal communication were irrelevant. Adelson argues that he should have been allowed to show the jury over 400 text messages taken from his phone. None of the text messages Adelson sought to introduce into evidence contained any relevant information. Also, some of the Adelson's texts contained sexual, racist, and misogynistic references that would have embarrassed Adelson had they been admitted. In any event, Adelson suffered no harm because he testified about the content of his text messages. A. Adelson invited the error he alleges on appeal. While the trial court would not admit all of Adelson's 400-plus text messages, the court said it would consider admitting individual messages that were relevant. But Adelson never offered any individual text messages for the trial court to consider. Thus, the trial court gave Charles Adelson an avenue to enter relevant text messages, but Charles Adelson declined to take it. This court, therefore, should reject Adelson's argument under the invited error doctrine. It is well-established law that where the trial judge has extended counsel an opportunity to cure any error, and counsel fails to take advantage of the opportunity, such error, if any, was invited and will not warrant reversal. B. If this court considers the admissibility of Adelson's text messages, the standard of review is fundamental error. Adelson's initial brief argues that the trial court should not have excluded his text conversations with Mark Banua, Donna Adelson, and Wendy Adelson. But Adelson's proffered text also included conversations with his friends, business partners, and other medical professionals. While the trial court would not admit all 400-plus text messages, the court expressed its willingness to consider any relevant nuggets that went to Adelson's state of mind. Despite the trial court's offer, Adelson proceeded without proffering any individual text conversations he had with Malbanua, Donna, or Wendy. And just a little break, proffering means like putting them on the record so that an appellate court could review them. Right? You can ask for the 400 email or text to be admitted, and then if the judge denies it, you got to proffer them. You got to put them on the record outside the presence of the jury so the appellate court can see what was it that you were trying to introduce. All right, back to the brief. So while the trial court would not admit all 400-plus text messages, the court expresses its willingness to consider any relevant. Because Adelson failed to proffer any individual text messages, the trial court never ruled on any text conversations involving Mike Vanua, Donna, or Wendy. Adelson's argument is therefore unpreserved.
If this court considers Adelson's unpreserved argument on the merits, it should apply the fundamental error standard of review. To demonstrate fundamental error, Adelson must show that the outcome of the trial would have been different had the trial court admitted Adelson's text conversations with Magbanua, Donna, and Wendy. C. Adelson never proffered any text messages from July 2014. Adelson's initial brief argues that his text messages showed that Adelson and his alleged co-conspirators. We were communicating normally during and around the time of the murder. But Markel's murder occurred in July of 2014, while Adelson's exhibit of 400-plus text messages detailed conversations that occurred between June 2nd and June 7th, 2014. These texts from June 2014 corresponded to the hitman's first unsuccessful attempt to kill Markel. Adelson's attorney stated to the trial court he planned on doing the same thing for July 14th through 19th. But Adelson never proffered any text messages from July of 2014. This court, therefore, should reject Adelson's argument regarding the relevance of his July 2014 text messages. D. Adelson's text messages were irrelevant. According to Adelson, his 400-plus text messages were relevant because they established reasonable doubt and demonstrated his state of mind. Adelson is wrong on both points. Generally, any evidence that could establish reasonable doubt is admissible, and a close call should be resolved in the defendant's favor as long as there is a possibility of the evidence creating a reasonable doubt. But evidence as to immaterial matters is inadmissible for any purpose. Adelson could not establish reasonable doubt by showing that he texted people about immaterial matters. Just because Adelson never texted Magbanua, Donna, or Wendy about murder did not mean
Just because Adelson never texted Magbanua, Donna, or Wendy about murder did not mean that Adelson was unaware of the plot to kill Dan Markel. Charles Adelson's texts were also irrelevant because they did not support his theory of defense that Magbanua and the hitman killed Markel in a scheme to extort Adelson. Adelson's other argument is that his text messages demonstrated his state of mind. This is wrong. Section 90.803 of the statutes recognizes two types of hearsay statements that are relevant to demonstrate the declarant's state of mind. 1. Statements that prove the declarant's state of mind at a time when such state is at issue in the action, and 2. Statements that prove or explain the declarant's subsequent conduct. The thoughts expressed in Adelson's text messages were not relevant to any issue in the action. Adelson's texts are also failed to prove or explain Adelson's subsequent conduct. Statements admitted under the state of mind exception to the hearsay rule are properly admitted only if they involve the state of mind of the declarant and there is evidence demonstrating that the declarant acted in accord with the state of mind or intent. The fact is that Adelson did not offer his text messages to demonstrate his state of mind. Instead, Adelson tried to use his texts to show that he had not aided Magbanua and Garcia in the plot to murder Dan Markel.
The fact is that Adelson did not offer his text messages to demonstrate his state of mind. Instead, Adelson tried to use his texts to show that he had not aided Magbanua and Garcia in the plot to murder Markel. But a defendant cannot offer state of mind evidence to prove prior conduct. Chief Judge Irvin recognized in Reed v. State that a statement of the declarant's then existing state of mind is admissible to prove or explain the declarant's subsequent conduct, but not his prior conduct. Like Adelson, the defendant in Cotton v. State tried to use his self-serving statements to show that he was unaware of a crime. The police caught Cotton with a package containing cocaine during a traffic stop. Cotton told the police that the driver had just handed him the package, and he had no idea that it contained cocaine. Cotton argued that his denial of guilty knowledge to the police came within the state of mind exception to the hearsay rule. The 4th District Court of Appeal rejected that argument. Instead, the 4th District held that Cotton's statement was precisely the type of self-serving exculpatory statement that has been traditionally regarded as inadmissible hearsay because of its lack of reliability and trustworthiness. While Adelson's texts were not expressly exculpatory, Adelson offered his texts for the same purpose as the statements proffered in Cotton, to show that Adelson was unaware of a criminal act. But like the statements proffered in Cotton, Adelson's texts were not reliable or trustworthy evidence of Adelson's ignorance of the plot to kill Markel. E. The trial court's exclusion of the text messages did not harm Adelson. This court should affirm, because the trial court's ruling did not prejudice Adelson, requiring appellate courts to affirm unless an error was committed that injuriously affected the substantial rights of the appellant. The trial court's exclusion of Adelson's text messages.
The trial court's exclusion of Adelson's text messages was harmless for 4 reasons. First, Charles Adelson testified that he reviewed every text message he sent and received between June 2nd and June 7th of 2014, and none of those texts discussed Markel's murder. The text messages themselves would have been cumulative to this testimony. Second, the texts would have likely angered the jury.
Some of Adelson's texts contained racist words and references. Other texts were sexually explicit. Still others were misogynistic. The trial court's exclusion of Adelson's distasteful texts avoided their prejudicial effect. Adelson therefore cannot complain that he suffered prejudice due to the trial court's ruling. Third, the jury heard recordings of Adelson speaking about Markel's murder after the bump. This evidence showed that Adelson preferred to speak about Markel's murder either over the phone or in person. Adelson also spoke very cautiously about Markel's murder, often using coded language. For example, Adelson had a phone call with Donna where she told Adelson that it's clear what's wanted. This TV is probably about 5 Donnas. Use of TV is significant because Adelson had joked that buying Wendy a TV was cheaper than hiring a hitman. Adelson knew exactly what Donna's coded language meant, and he responded, "They asked you for $5,000? Another example was Adelson's conversation with Magbanua at Dolce Vita restaurant, where Adelson spoke of a horrible crime involving a gun. During this conversation, Adelson posited a hypothetical resembling Markel's murder, where the killer would rent a car and drive to Orlando to rob a McDonald's. Because Adelson was so cautious about discussing Markel's murder over the phone and in person, the jury would not be shocked to learn that Adelson avoided discussing the murder over text. Adelson's attorney even admitted during closing arguments that it did not make any sense for a guy who was about to murder someone to go around town and advertise it. Fourth, Magbanua's testimony crushed Adelson's claim that he was unaware of the plot to kill Markel. Around Halloween of 2013, Adelson asked Magbanua, "Do you know anybody that can harm someone?" In response, Magbanua said yes and kind of left it alone. Later, Adelson told Magbanua that he wanted Wendy's husband killed. Adelson claimed that Wendy's husband was a terrible man and making his family go through a lot custody-wise with his sister. According to Adelson, this turmoil had caused his mother to stop eating and sleeping. Adelson added that his father's health was also in decline. Magbanua said that Adelson became a little more adamant about this job getting done in June of 2014. Adelson initiated Markel's murder by giving Magbanua a manila envelope containing the information Garcia would need to find Markel. Adelson took steps to ensure that his DNA and fingerprints would not be on the envelope or its contents, and he advised Magbanua to do the same. It was clear from Magbanua's testimony that Adelson kept his discussion of the murder plot to a minimum and preferred to communicate about the murder in person. Magbanua's testimony also showed that Adelson took measures to conceal his connection to Markel's murder and the hitman. The jury, therefore, would have been unsurprised to learn that Adelson did not text about the plot to kill Markel. Issue 4. Adelson's out-of-court statement about extortion was inadmissible hearsay. Adelson claims that the trial court should have admitted a phone call where Adelson spoke with Donna about extortion. In this call, Adelson told Donna, I'm just telling you it's not done like that. It's not. I know for a fact it's not. It's not done like that at all. It's not done in such a nice manner. According to Adelson, this statement proved he had been the victim of extortion. Adelson's statement in this phone call was inadmissible hearsay because it was offered for the truth of the matter asserted, that Adelson had experienced extortion. Also, Adelson's statement did not fall under the state of mind exception to the hearsay rule because it described the past conduct of other people. A. The standard of review is mixed because Adelson never argued that his statement was not hearsay. When the trial court asked Adelson's lawyer why Adelson's statement was not inadmissible hearsay, Adelson's lawyer responded that the statement went to Adelson's state of mind. In other words, Adelson argued that his statement was hearsay, but subject to an exception to the general rule prohibiting hearsay evidence. But on appeal, Adelson makes an additional argument. His statement was not hearsay because it was not offered for the truth of the matter asserted. This argument is unpreserved because Adelson did not raise it in the trial court. Adelson's argument that his statement was not hearsay is subject to fundamental error review. This court should review the trial court's rejection of Adelson's state of mind argument for abuse of discretion. A court abuses its discretion when no reasonable person would take the position of the trial court on a matter, considering any findings which are supported in the record. B. Adelson's statement alluding to extortion was hearsay. Adelson argues that his statement alluding to extortion was not hearsay because it was not offered for the truth of the matter asserted. Adelson is wrong. Adelson wanted the jury to believe his statement about extortion was true, so his statement was hearsay. This court recognized in Chapman v. State that if an out-of-court statement is offered in court to prove the truth of the facts contained in the statement, it is hearsay. C. Adelson's remarks about extortion did not fall within the state of mind exception to the hearsay rule. According to Adelson, his statement about extortion fell under the state of mind exception to the hearsay rule. Adelson's argument fails for 3 reasons. First, Adelson's statement did not fall under the state of mind exception because the statement did not reflect Adelson's mental or physical state. Section 90.8033 allows hearsay evidence that shows the declarant's then existing state of mind, emotion, or physical sensation, including a statement of intent, plan, motive, design, mental feeling, pain, or bodily health. Instead of offering his statement to reflect his state of mind, Adelson offered his statement to prove that Garcia and Magbanawa extorted him. Second, Adelson wanted to use his statement to show he had been extorted in the past, but the state of mind exception to the hearsay rule only encompasses future conduct, not prior conduct. About extortion fell under the state of mind exception to the hearsay rule. Adelson's argument fails for 3 reasons. First, Adelson's statement did not fall under the state of mind exception because the statement did not reflect Adelson's mental or physical state. Section 90.8033 allows hearsay evidence that shows the declarant's then existing state of mind, emotion, or physical sensation, including a statement of intent, plan, motive, design, mental feeling, pain, or bodily health. Instead of offering his statement to reflect his state of mind, Adelson offered his statement to prove that Garcia and Magbanawa extorted him. Second, Adelson wanted to use his statement to show he had been extorted in the past, but the state of mind exception to the hearsay rule only encompasses future conduct, not prior conduct. A statement of the declarant's then existing state of mind is admissible to prove or explain the declarant's subsequent conduct, but not his prior conduct. See also R.J. Reynolds Tobacco Company versus Hamilton, a hearsay statement which recounts observations made previously is by definition an after-the-fact statement of memory, and expressly excluded from the state of mind exception. Third, Adelson could only use the state of mind exception to explain his own conduct, not the conduct of another. Adelson, therefore, could not use his own out-of-court statement to show that Garcia or Magbanawa extorted him. Citing to a case holding that victim's statement, "Dr. Shepard has poisoned me," did not fall within state of mind exception. These evidence of the declarant's state of mind is only admissible to explain the declarant's actions, not as proof of an act committed by someone else. See also Cybers v. State. The courts of this state have repeatedly held that out-of-court statements cannot be used to prove the state of mind or motive of someone other than the declarant. D. Excluding Adelson's phone call did not prejudice him. Adelson must demonstrate that the trial court's ruling excluding his phone call was an error that injuriously affected his substantial rights. Adelson fails to meet this burden for 4 reasons. First, Adelson's statement to Donna suggested that he was familiar with the concept of extortion, not that he had been the victim of extortion. But most people are familiar with how extortion works, even if they have never been extorted. Adelson's statement, therefore, was marginally relevant at best. Second, Adelson was allowed to testify about the contents of his phone call with Donna. Adelson told the jury that he advised Donna that "It's not done this way, I know for a fact, and I'm 99% sure it is what I thought it was." Third, the jury heard Adelson make an almost identical statement to Donna in one of the phone calls that the state published. The jury heard the state's Call R, where Adelson and Donna discuss the bump. In that call, Adelson told Donna, "I actually do know how these things are done. And that was the same thing that I said. It's not done like this." When Adelson took the stand, he explained the above statement. According to Adelson, he meant that it's not the same people that extorted me that are extorting Donna. It's clearly not the same as the first extortion. Fourth, other phone calls between Adelson, Magbanawa, and Garcia disproved Adelson's story about being extorted. After the undercover FBI agent approached Donna, Adelson called Magbanawa and explained that he believed Donna was being blackmailed. During this conversation, Adelson brainstormed with Magbanawa as to who might blackmail Donna. But Adelson never said anything that implied that he had been extorted too. Later, Adelson called Magbanawa to tell her about a birthday present Adelson had left for Garcia. Adelson said, "If you don't think it will cause anything, you can tell him it was from me when he opens up the present." In another call between Adelson and Magbanawa, Adelson revealed that he was aware, but not surprised, that Katie's baby daddy, Garcia, called the undercover FBI agent on Adelson's behalf. In a subsequent phone call, Magbanawa told Garcia, "I told Adelson, like, you'd help him, you know." "I'll try to help out," Garcia replied. "You know what? I'll take care of it." Later, Adelson called Magbanawa to let her know that the undercover agent was a pot-bellied pig. In this call, Adelson asked Magbanawa, "You know what a pig is?" These phone calls did not depict Adelson interacting with his extortionists. Instead, these calls revealed that Adelson, Magbanawa, and Garcia were co-conspirators that cooperated to determine the identity of the undercover FBI agent. Issue 5. Adelson's cumulative error argument fails because his other arguments are procedurally barred, meritless, or both. Adelson argues that the alleged errors in his other 4 arguments resulted in a cumulative error that deprived Adelson of a fair trial. But all of Adelson's other arguments are procedurally barred, meritless, or both. Outside of his 4 main arguments, Adelson alleges no additional errors that affected his trial. Adelson's claim of cumulative error, therefore, necessarily fails. where the alleged errors urged for consideration in a cumulative error analysis are individually either procedurally barred or without merit, the claim of cumulative error also necessarily fails. Conclusion: any Florida jury would have convicted Charles Adelson for effectuating the murder of Daniel Markel. Adelson was an essential link between Markel and the man who killed him, Sigfredo Garcia. Catherine Magbanawa was the other essential link between Garcia and Markel, and her testimony explained how Adelson was the driving force that caused Markel's death. Adelson's text messages and phone calls could not have changed the outcome of his trial. This court should affirm Adelson's convictions for first-degree murder, conspiracy to commit murder, and solicitation to commit murder. Okay, that is it for the answer brief. Next in the process will be Charles Adelson's lawyers filing a reply brief. Then, the court will decide whether to hold oral argument. It may take months before we see a conclusion to Charles Adelson's appeal. Until next time, Deep Dive True Crime.
Very serious.